Hello, and welcome to our webinar this morning that we'll be doing on Schrems and discussion about tips, trends, and what we're seeing in the marketplace today. Today, we're very excited to have Jill Abbott-Bohl, who's with us from Cybersecurity Law Report, co-founder and president Aaron Weller with Ethos Privacy, and Jim McKenzie, Director of Consulting at Ethos Privacy. Just a bit about Jill. So first of all, Jill is a senior editor with the Cybersecurity Law Report. The Cybersecurity Law Report is an information service providing business analysis and practical guidance. Jill manages the editorial content and writes and speaks on a range of cybersecurity and data privacy topics. She spent much of her legal career as a litigator at Dentons, where she gained significant experience in both state and federal courts on a wide array of matters. Aaron Weller. Prior to forming Ethos, Aaron was a managing director at PwC, specializing in data privacy and protection. Before PwC, Weller had co-founded Concise Consulting, where he worked with Fortune 250 and other national organizations to develop a sustainable privacy and security consulting business. As the respected authority on IT risk, privacy, and security, Aaron is a frequent speaker at national and international conferences. And Jim McKenzie is a director of consulting at Ethos Privacy. Jim is a senior consultant specializing in privacy, data security, and regulatory compliance matters. His specialties include privacy and regulatory compliance, program design, assessment, and remediation, as well as policy procedures, gap analysis, development, implementation, and enforcement. This is a great panel for the conversation we're about to engage in. So I'm going to share my screen.
Hi, everyone. Welcome. Thank you for joining us today to discuss the dynamic world of data transfers. We will start by talking about common data transfer challenges, and then we'll cover some of the ways companies can approach the data transfer steps like transfer impact assessments, updating standard contractual clauses, and all that fun stuff. I'm excited to be discussing this topic with our very impressive panelists and get their practical advice on managing this complex landscape. Before I kick off, I just want to invite those listening to put any questions they have in the Q&A, and we can save some time at the end to address them. But we do have a lot to cover today. So just to set the stage a little bit before we dive into all the specifics, it's been a year and a half since the Schrems 2 decision came out, invalidating Privacy Shield and impacting data transfers from the EU to the US and elsewhere, meaning that transfers of EU personal data to US companies that fall under US surveillance laws and may consequently get disclosed to US authorities violate the GDPR unless additional safeguards are implemented. Following that decision, there's been guidance from the European Data Protection Board on supplementary measures to add to SCCs to provide sufficient protection around transfers to the US, where contracts alone would not suffice. We had new SCCs come out last September with the requirement that companies update their current SCCs in place by September 27th. And we have now seen a series of enforcement actions come out since the Schrems 2 decision. Until Google Analytics, those actions focused on the public sector or particularly sensitive data, or on process failures like not conducting a transfer impact assessment. As we'll discuss in more detail today, however, the recent Google Analytics cases may now increase the risk landscape for companies because they focused on the commercial landscape. And there are at least 100, I think it's 101 cases like it due to follow. So all of this while we wait for a new Privacy Shield. So with this landscape in mind, I think Karen was going to put up a poll just to sort of assess where our audience is on how far they are with their Schrems 2 efforts. While the poll is up, I think we could start with our questions because we have a lot to cover today. So let's talk a little bit about some of the challenges here. Aaron, I'd like to turn to you first to address what are the biggest compliance-related data transfer challenges plaguing businesses, both in the EU and the US post-Schrems 2?
Thanks, Jill. I think one of the major challenges is that companies don't know what good looks like. And as we're seeing, some of the regulators don't really agree on what good looks like either. Companies are trying to do the best they can. In many cases, a lot of the companies we work with are trying really hard to make sure that they are taking efforts to comply with the requirements. But at the same time, there's a lack of guidance and some uncertainty. You mentioned the recent court rulings. It leaves companies not very much to go on. And really, what we're seeing is that there's still a little bit of uncertainty around what do we really need to do. I think fundamentally, data flows can't stop. That's not really an option for most companies. And I don't think that's really where any of the players in the ecosystem, even Max Schrems, I don't think really wants the data flows to stop. I think the potential of stopping them can certainly be used as a lever to drive change. But fundamentally, all of the impacted governments and all of the companies want the data transfers to continue. So that's kind of the we've got a little bit of there's some guidance out there. People know some of the things they should be doing, but I think what we're in this stage of at the moment, as we're counting down towards the deadline, is what's the plan that we need to put in place that kind of gets us to that right level of risk, given how fluid the situation is, even after the ruling came out.
Right. Yeah, I mean, in talking about that level of risk in terms of companies expanding that risk profile, I mean, we've heard that some companies are really continuing to take that business as usual approach, which might be a bit more risk than they may want to actually assume in reality. But let's talk a little bit about some of the pain points here. First one being the transfer impact assessments. Jim, I'm interested in hearing your thoughts on this. From what you've seen firsthand, have most companies that are required to, for purposes of data transfers under the GDPR, completed their transfer impact assessments at this point?
I think the answer to that is no. Interestingly enough, the poll that just came out, there were several that have already started, but very few that have completed, unless they have a small volume of vendors or customers that they're processing. On the larger scale, it's such an onerous process, or what we're finding to be an onerous process, that companies that are in the process of doing it have not completed it, and are looking at that deadline at the end of December as coming very, very quickly. What's also interesting is sort of the timing. We've had clients that have started this process going back over a year, and considering that in a majority of cases, privacy professionals have indicated that data transfers and the Schrems decision were number one on their list of concerns. But a small percentage, about 10%, have actually indicated they're going to stop transfers or go to a localized data solution. But with that being said, considering that not many have completed the process, in a large part haven't even started it. So that's pretty much what we're looking at in terms of the process. And what we're seeing again is it's a very onerous process. So if companies haven't started or even thought about it, now certainly is the time to start.
Yeah, absolutely. Yeah, it was interesting. I was looking at the poll too. It looks like there's a lot, the majority are really falling in that sweet spot in terms of their, they have something underway. But for those who really haven't started the TIAs, what, Aaron, maybe you could speak to this, but what's holding them back? Jim mentioned that it's just a burdensome process. Is that what it is? And if so, what steps can they take to overcome that?
Well, I think it could be a couple of things, depending on the size of the company. A lot of companies don't even really know where to begin. If you don't have a lot of documentation around your privacy programs, there's a lot of work that needs to be done, even to understand what data you have, who do you share it with. If you haven't gone and, it's boring but important to make sure that you have an up-to-date understanding of kind of where that data is, what's the latest version of the contract. But I think it's important to recognize as well that when you look back at the impact of losing Privacy Shield, it was mostly small and medium-sized organizations that were most impacted. Right? There were over 5,000 participants in Privacy Shield. Over 75% of those were small and medium businesses. And I think the other piece of that as well is what's holding them back is if you're a small and medium business, I don't think you'd necessarily see the threat of enforcement the same way as maybe if you're a large multinational. So we see organizations at both ends of that spectrum. But I think we do have as well, there are some organizations we work with where they've had a good plan and they've been working that plan for some time, as Jim mentioned, in some cases over a year. So I think we have seen organizations that are working really hard towards this, doing the best they can, given that the guidance has come out and changed and the court cases, some of the plans that were made several months ago, then need to go back and be readjusted. Probably the other thing to think about as well is that we're looking at contracts that could be owned across the entire organization. So what we found, and I think Jim will talk about this in a minute, is there's a lot of what one of my clients called stakeholdering, which is really that process of engaging and maintaining those relationships with the people who actually own those relationships with the third parties. A lot of that is really, you could argue that's not even really privacy work, but it's something that a lot of privacy teams are finding has to be done to even understand what the transfers are, so that they can make those decisions like, where do we need a TIA? How should we go about getting that done?
Yeah, I mean, like with a lot of privacy, there's obviously cross-functional aspect to this as well. So like you mentioned, that's a good point. And you also mentioned, Aaron, that, something that's holding companies back is just not knowing where to begin. But there are a number of companies out there, almost as evidence a little bit by our poll, that they've sort of done something so far that have the basics done, like data mapping. And then for those companies, and Jim, maybe you could speak a little bit more to this, what's holding them back? I mean, obviously there's still burdens, there's still, the resource issue. Is that what you're seeing? And, if so, what can they do to?
Yeah, I think there's several factors, Jill, to be honest. I think one, and actually with a lot of the recent news coming out of the EU-US deal, I think a lot of people are kind of hoping that a deal is going to get done. I think I just saw an article today, as a matter of fact, where they're signaling that they're close, and they may even be as close as having determination in the May meeting in France. So I think that's one of the things holding companies back. Another is just, again, to what Aaron was saying, they don't know what good looks like. So, we've seen several, well, I shouldn't say several companies, but we've seen instances where companies have gone through iterations of what their TIA looks like. So how in depth do they need to get? What are the questions they need to ask? How much do they balance the security side versus the privacy side when they get, certain questions and responses? Now they have to go back and clarify and get additional information. So I think just the whole process in and of itself with the whole TIA could be daunting and holding companies back. And again, we've seen companies struggle with vendor data. So they don't even know what vendors are in scope or where they should begin. And a lot of the lead up to this is, identifying the data, the vendors in scope to begin the process. So we're seeing a lot of that, internal systems. If they don't have good vendor management systems, that could also be an issue. If they don't have the internal support or resources identified, budgets. So there's a whole lot there that could be holding companies back and just making it a very, where do we begin sort of question.
Yeah. Then I guess then the second part of what I was asking is, how do they get past that? Then there's the resource issue. Obviously, there's the cross-functional issue, and then there's just the daunting.
Yeah, I mean, you just almost have to roll up your sleeves and just start the process. Reaching out to internal resources, leveraging your legal and compliance groups, your procurement groups, your vendor management groups, leadership, just getting everybody around the table and coming up with a plan and starting the process. And it's hard to have the conversation without knowing what the scope is. So the first thing you should start looking at is what are the vendors in scope? Do you know your high priority vendors? Have you started the bucketing process in terms of which ones you want to go after? Your large complicated vendors versus your web hosting or email hosting vendors. So, picking a starting point and then just, putting a plan in place. And then again, what does that TIA process look like? So, and how are you going to tackle that? Is it going to be an automated process? Is it going to be a web form? Is it going to be Excel spreadsheets? So, none of those are all those are solutions, but it all depends on the organization.
Yeah, I think, Jim, just to kind of follow up on one of the points you raised, not all transfers are created equal. And that's kind of really where you were saying with the risk assessment process. So if you're trying to create a defensible position, if a regulator does come and say, show me what you've done with compliance with Schrems, having a plan and saying we started with the vendors that we deemed the highest risk based on these factors. I think that's where you can then break down your vendor population as it becomes clearer what that population even is into a number of tranches or waves, and start with the ones that are most impactful, because as with all of these processes, you're going to find there's a long tail of organizations where maybe you share very limited data with. And at that point, the TIAs or the risk would be very different from the organization that maybe hosts your CRM system or one of the major systems you use to run the business.
Right. And I think just to add a little color to that, I think it's important to approach the TIAs with a practical mindset, which is essentially what you guys are saying, given that companies really want a solution that allows them to keep doing business. That's the point. And there's really no one standard. Like you said, they have to look at the specific facts in relation to their organization, as you mentioned, and to each processor really, in terms of what those businesses do, what types of data is being transferred, whether the processor is subject to surveillance laws, whether it's ever received a request under the Foreign Intelligence Surveillance Act, FISA 702, which I'm going to assume most of our viewers today are familiar with. And if it's subject to FISA 702, then what security measures it has in place. So yeah, absolutely good points. And then once the process is sort of underway, Jim, can you talk a little bit about what that ultimate report looks like?
In terms of a report, it's not, it's really evaluating what the responses are that you get back from the vendor. Again, from what they're doing around security. Most questions resolve around encryption. Are you encrypting your transfers in motion as well as at rest in some respects? And then again, what data is involved, what countries you're transferring data to, whether using third parties. We had a discussion the other day around sub-processors and what's the obligation of controllers and processors to look at their sub-processors, and sort of where does it stop? You're boiling the ocean at that point, and what are your obligations? And again, for lack of guidance, what does that say to the process? And then once you've got your data, your countries, your technical, what does all that mean? So again, despite the TIAs that we've been involved with, we have yet to see a transfer actually get halted or stopped because of the responses of the TIA. So, which is a very interesting, an interesting outcome, considering that, I think regulators are sort of looking for, hey, when we get into this, we're going to start seeing data transfers getting stopped. And I don't think that's the case at all.
Yeah, I think to back up a little bit, Jim, and to answer the question that came in the chat about what's actually in the TIA at a substantive level, it's really just another kind of privacy risk assessment focused on that transfer of data out of a country that's directly subject to GDPR to another country. I mean, we typically talk about the US, but that's not necessarily the only place that that data may be transferred to. And I think, as Jim touched on, there's really a couple of major pieces to this. One is around the third party itself. So what are the risks associated with that transfer on the basis of the nature and volume of the data being transferred and the control environment in place at that third party? So really a lot of that would be very similar to work, hopefully, that you'd already done as part of the vendor onboarding process, with a little bit more focus in on a couple of those transfer related areas. But in addition to that, there's then, as Jill, you mentioned earlier, kind of that country specific component where you have to look at what's the risk associated with a particular country outside of the individual vendor piece. So you've got kind of this combination of what are the risks associated with transfers to this country, and then what are the risks associated with transfers to this company in particular, given the nature and size and volume and complexity of those transfers as well. So when you look at it like that, there's a lot of these things that are very similar to other processes, but there are some nuances, and there are some good templates that have been published as well around what questions should you ask as part of the TIA process. But think of it like any other risk assessment where you're going to come down to, at the end of the day, not inherent, a residual risk based on that combination of those two things. But then, as Jim said, in practice, because everybody wants the data to keep flowing, we don't tend to see very many circumstances where those data transfers are actually stopped as a result of the TIA. Although we do have clients who have a process set up to, if the risk assessment does look like that's going to happen, then to go back to those business owners of that relationship and say, this is where we are, like, let's make a decision that takes into account both the privacy and the business considerations too.
Right, and to your point, Aaron, working closely with InfoSec and others in the organization, just in case the remediation is technical, or if they're relying strictly on SECs, so working with legal to update contracts.
Yeah, and talking about that, Jim, I think that's a good segue to talk about actual transfer mechanisms, which is obviously intertwined with the TIAs and part of that process. Maybe we could turn back to you on this, Aaron. In general, then, what alternatives to Privacy Shield are there now available to EU-based companies that need a legal mechanism to transfer personal data outside the EU, particularly to the US, in order to comply with the EU data protection rules?
Well, there's really a couple of options available, but none of them are really a perfect solution. And I think that even a future Privacy Shield will probably not be a perfect solution either. But if you run through them, so binding corporate rules, expensive, but they're only intra, not inter. So that doesn't help with the transfers to third parties, although it could help for those intra-group transfers. But the backlog for those is pretty significant. Because they're very complicated, and the regulators are, there's a lot of people who, when the Schrems decision came down, or even looked like it was going to come down, they wanted to try and put those into effect. So not necessarily an option for very many organizations, and it still wouldn't solve the complete problem. Standard contractual clauses, which is really kind of what we're talking about as being the main mechanism in light of Privacy Shield being deemed to not be compliant, it doesn't negate the obligation to do TIAs. And there was a comment in the chat that the concept of a TIA completely ignores treaties and necessary transfers. And to an extent, that's kind of where you've got this almost a conflict of laws issue between, it's really, as we all know, all European countries also have their own intelligence agencies. They also share data with the government for, they have legal reasons to do so. So it's one of these things where, because, as some of the arguments say, the US does not have a standard federal law that applies to all kinds of personal data, you've then got this imbalance that they're trying to fix with these different transfer mechanisms. There is provision in the GDPR as well for an approved code of conduct that people could sign up to, which really, if you think about Safe Harbor and Privacy Shield, a large part of that was an organization saying, yeah, we will operate our processes, our privacy program at a level that's equivalent to the GDPR, but we don't yet have that in place either. So really, as you can see, none of those options are great, which is why I think a lot of us are hoping that at some point we will get an approved mechanism which effectively provides that code of conduct, means we don't have to go through and do all of the detailed analysis for every single third party, but we're not quite there yet, as Jim mentioned.
Yeah, I'm hearing the same thing that you guys are hearing, really, that companies are relying on SEC still as the primary means for continuously transferring data from the EU to the US. Companies are conducting their TIAs for those who are at that point. And then they're just relying on the new SECs, knowing that they're going to be imperfect. Though the new SECs, I guess, compared to the older version, may be more likely to provide sufficient level of protection. And it's also worth noting that in this new version of the new SECs, there is a footnote And it's indicated, I guess, in a footnote that when warranting that no laws prevent the company from complying with the GDPR, parties may take that risk-based approach that we've been talking about. So Aaron, I'd like to continue with you to ask, what does that risk-based approach look like for a controller that's transferring data to a customer in the US that has never received a government request for data under FISA 702? How do they check the necessary boxes?
So we've got, and I've actually been in a room with a regulator that asked that question around 702, where 702 is very narrowly scoped. It doesn't apply to probably most of the organizations on the phone. So the first thing to work out would be whether you're even in scope for potential 702 requests. If you are, you will know how many of those you've received. And you know, while there are certain restrictions on what information you can provide externally, companies in recent years have produced transparency reports with ranges. So I think that's really can be useful to help push back and say, and I was talking to a German regulator where the German government had actually made more requests for data from that organization than the US government during the previous year. Which the regulator was surprised to hear, but it comes back to my point earlier that it's not just the US that does ask for data from companies. There was a comment in the chat that the government doesn't have any interest in the type of data stored. Most of the time, I would agree with that. I think that, but there are some things where if you're trying to track down organized crime, counterfeiting on a large scale, there are some circumstances where some data could be useful. But I would agree that out of the sea of all of the data, that the chances are that a lot of that is going to be of no interest to governments anyway, which is you can go back and look at the data and say, you know, what kind of government requests are we actually receiving, and how many of those we're actually responding to, because not every government request actually is responded to with the data. Some of them are, you know, they're misdirected, or they're kind of they're too broad in scope. So working with whoever handles your government requests, just to get that other part of the picture together, if you're actually having to go into that scenario where you've got to justify the work that you've done.
Yeah, that's a good point. And then, you know, sort of to add what you were saying about sort of justifying the work that you've done, another key step that's worth noting is, you know, whatever a company decides to do or not to do, that the case-by-case analysis that we've been talking about should really be documented. So even if the solution reached isn't perfect, which it sounds like it can't be really right now, there will be a record that the company went through the necessary steps. And, you know, we've had sources tell us that it's really unlikely that the company would face large fines, at least initially, if it has been thorough in reviewing the EDPB's recommended factors and the TIAs and then documenting that. So we've been focused on the TIAs, and we're talking about the SCCs being the primary transfer mechanism that companies are using. So companies have to update these SCCs with new ones now by December 27th of this year. Jim, particularly for companies with, and you started to talk about this earlier, with hundreds or thousands of vendors, that's obviously going to be a significant undertaking. How are they going to manage this task?
A great question, Jill. So as I indicated earlier, planning is a major part. So you really want to take time to understand the steps that are necessary to engage in large-scale contract updates. Companies may have done it as part of CPRA or CCPA back in the day, or for other reasons. So you may already have a good indication, but you know, really identifying and engaging, you know, the internal and to some extent external resources, if you're going to rely on outside counsel for contract negotiations or well, not really negotiations, since SECs really can't be negotiated, but at least getting the contract signed. Again, you know, do you have the budget set aside to engage external resources? Communicating with leadership, making sure that leadership as well as business units are aware of the ongoing efforts. So when they get a request, they're ready to respond. Determining the best and most efficient way to engage in your vendors. So is it through emails or through phone calls? Do you have the right information in place to do the initial reach out? And then planning for roadblocks. So as I'll talk about here in a minute, it's not a smooth process. So planning would be the first. Getting organized would be the second one. So again, identifying your in-scope vendors. That can be a daunting task, especially if you have multiple vendor management systems. If you're not a centralized vendor management organization, if you allow business units to contract with their own vendors, then reaching out to those different business units can be a process as well. And what kind of data do you have on your vendors? So if your vendor data is old or it's not kept up to date, then you may be reaching out to individuals who are no longer at that vendor, or the vendor may not even be active contract anymore. So then you're chasing your tail, trying to figure out who's in scope, and then start with a prioritization. So once you have your in-scope vendors, which ones do you want to start with? Again, I think a lot of the focus is on web hosting and email hosting vendors, your telecommunication vendors, vendors who are transferring large amounts of data, large amounts of PI. And then looking at your Privacy Shield, your former Privacy Shield vendors. So who is actually under Privacy Shield certification prior to the Schrems decision. And then your known data sharing vendors. So outside of the ones we just mentioned, which other ones do you know you're sharing data with, and they're maybe sharing data with sub-processors. So getting that prioritization is key. And then you have a good story to tell, right? If you ever get the knock on the door from a regulator, you can say, hey, we start with this process. Here's, we have these plans in place, and we're starting with these vendors, and this is why. So you get to tell a good story. And then again, utilizing internal resources. So, who do you need around that table, from legal to IT, for InfoSec, leadership, and just maintaining that communication. So whenever you need a resource or you ever need to chase data, you have the right people to ask. So the third would be, and then to anticipate the roadblocks. So as I indicated, this is not a smooth process. We've seen this in practice. You might get the vendors who don't respond, or non-responsive vendors, and then you have a decision to make, right? How do you deal with them? Do you terminate the contract altogether, or do you try to find other ways to reach out? Do you reach back to business units, business points of contact, reach out to their DPOs, whatever it might be, to try to get some communication? Ultimately, hopefully you do. If you don't, again, you have that decision to make. How valid is the vendor to your business operations? Is it, what's the risk for terminating that relationship versus continuing on with that relationship? And then again, those internal points of contact that'll help you sort of navigate those roadblocks. Having somebody in place, or a committee in place to make those decisions on those vendors who are non-responsive, or who ultimately don't want to put any corrective actions in place. So based on the results of the transfer impact assessment, whether it's a technical solution, a contractual solution, or an operational solution, if a vendor is not willing to negotiate the contracts, again, you have that decision to make. How vital is it to the business, and whether you continue with that relationship or not? And then, a plan for the signing process, right? Not every contract or every vendor is going to sign right away. So there's going to be a lot of back and forth. So there's a lot of runway there that you have to negotiate in terms of planning out, making sure everything's updated by that deadline at the end of December. So that's where I would start in terms of getting the process in place. It's a lot, but
It's a lot. That's good though. That was very helpful, actually. That provided a good roadmap. And I was sort of focusing on not to be so negative, but the roadblocks, and when that might lead to termination of a relationship with a vendor. Maybe you both can speak to this. I know, Aaron, you're going to probably have something to add here, because I know you have a lot to say about this this issue with keeping those contracts and managing those contracts in scenarios like this. But how often does something like pushback or lack of response from a vendor really lead to termination in reality?
How often does it lead to termination? Not very frequently in our experience. I think you can, if you put vendors on a bell curve, you find some that will be like, sure, we've got a process, we're going to sign this, it's going to be done already. Jim loves those vendors, but the majority of vendors there might be a little bit of back and forth. You might reach out to the wrong person. It takes a little bit of time. And then there's those that really, they either go completely silent or they are just intransigent in terms of, we don't want to sign these. We want to make red lines to the standard contractual clauses. No, you can't do that. Here's the reasons why they're standard. So there are some where we've got to the point where you then have to go back to the people who own that relationship in the business and say, what do you want to do now? And this was the same even before Schrems came out, when we were updating contracts for CCPA as well. You see the same kind of thing where there are some vendors who either they don't have anyone responsible for privacy at the vendor who doesn't really understand what you're asking or why, or doesn't feel empowered to be able to sign what looks like some fairly onerous requirements without really understanding them. So sometimes that's a little bit of education, but we have had scenarios where I've seen, we've had to call up the VP or whoever on our client's end and say, you need to get these guys on the phone one way or another and explain to them this is actually important. And whoever, even if they have to get their outside counsel on the phone because they don't have anyone internally, let's go through and work out kind of what a next step is. So we don't tend to see very often that the transfers are cancelled. I think it's interesting in light of the recent Google Analytics decisions around, now that that's been done, are we still starting to see people, we're still in kind of a wait and see mode with the companies that we're talking to, where nobody wants to be the first, right, to cancel, particularly if they're a large vendor, because you don't want to be the one that's going back to the business saying, we've got to switch email systems because we couldn't get a response out of the vendor. I don't think that's a very likely scenario.
Yeah. That's a good segue. Let's talk about those enforcement cases for a second, the Google Analytics cases. As a lot of people know on the call, in January, the Austrian Data Protection Authority ruled that use of Google Analytics and the resulting export of data to the US violates GDPR's export requirements. Then a few weeks later, the French Data Protection Authority, the CNIL, also confirmed that these personal data transfers to the US are a violation of the GDPR. Slightly different analyses there and facts, but these are the first decisions from the EU data protection authorities in response to, I think it was 101 complaints filed by privacy advocacy group NOIB that Schrems co-founded, and following that Schrems 2 decision. And that's a very general characterization of these decisions, and I don't need to give the analysis short shrift. But most importantly, we're talking about the practicalities here. So Aaron, maybe sort of continue what you started and comment on what impact these recent cases have on companies that are trying to navigate the data transfer landscape.
I think in the short term, we're still seeing a lot of wait and see. As I said, nobody wants to be the first to say, we're going to turn off this functionality that's potentially business critical, and we may not have a good solution. I do think, as you mentioned, there's 101 cases that were filed. We've seen the results of 2 so far. So it might be that it gets to the point where either, and we've seen this in the past, where some of the big tech companies rework a particular thing that they're doing to more closely comply with the requirements. Different versions of telemetry or an EU data boundary or other things that you can then say, well, they've made changes since you did the analysis, so we think we're okay. But I think at the moment, there's very little for companies to do. I wouldn't want to be the privacy person who's going to go to a business group and say, hey, because of this one court case, we're now going to stop something that's really important to the organization. But I think that pressure will continue to grow, which is exactly why those cases were filed in the first place, to drive companies into potentially very little options apart from terminating that transfer. But I would imagine that that's one of the things, again, that's driving we're trying to get to some kind of an agreement that then all of these things go away in light of that until, some new challenge will be made against whatever the new agreement is.
Yeah, and we'll get to that. But right, I mean, in most cases, companies are going to be using Google Analytics simply because they don't have any other options. And it's hard for some companies to move away from using it because they rely on it for their business. So yeah, in terms of other options, unless Jim, did you have anything to add to what Aaron said there?
I think he's spot on. It's a sort of wait and see. Again, to Aaron's point, I don't think anybody wants to be the first one to pull that trigger, and certainly don't want to go to leadership and say, hey, we're gonna stop this transfer for these few cases. So I think that's he's spot on with that analysis. But again, depending on the outcome of these 101 cases, will determine what the next steps are. So
I think maybe one point of clarification is that that's for the existing transfers where you're effectively breaking something by stopping them. I do think that there is something that you can do with potentially new transfers. So when you're looking at doing a vendor selection process, I think making sure, and I had a call with a client on this earlier this week, with when you're looking at how should you be thinking about the risks associated with new transfers before you get to that point where turning something off is going to break it. And that doesn't mean that I'm saying that you shouldn't be using American companies by any stretch, but at least kind of including that in the analysis. So you can do that as part of we've been thinking about the due diligence. Are there alternatives? Because I think otherwise it's easy for a regulator to come back and say, you didn't even consider this factor when you were deciding to go with this company versus that company. So that for me is all part of the overall, not just what are we doing now to kind of clean up where we are, but in terms of thinking about going forwards, I do think we should be more thoughtful about, where is this data flowing? What are the rules in different parts of the world? And how do we take that into account when we're making these kind of business decisions?
Yeah, that's a great point, Aaron. And one of the things that we're doing as part of our engagements are working with our clients to make sure that the improvements that we recommend, or that we're, the roadblocks that we're seeing and the recommendations for improvement are getting incorporated into existing processes. So, to Aaron's point, as you look at your vendor management process, your third-party assessment process, incorporating what the TIA is basically essentially put out to do is to look at those transfers, look at the vendors who are getting data. Are they engaging in a data transfer? What countries are involved? And, basically putting the controls in place. So now you're doing that ahead of time versus reactionary, and then making that part of the decision making, whether you move forward with that vendor or not. And a lot of these decisions will come down to what is ultimately going to be decided in some of these court cases, or Privacy Shield 2.0, whatever comes out. But in the meantime, you're now hedging against having to redo this process or having to go through a similar process. So we're looking at the vendor management systems as well as the vendor assessment process, making sure that all that data is getting incorporated. So again, if clients have to redo this process, much better data, much better processes in place for hopefully a smoother engagement.
Yeah, and in working with your clients, are you guys seeing that in terms of who you're dealing with at the company? Are you dealing with a cross-functional team, or are you usually, on processes like this, are you usually speaking to procurement or privacy, or just general counsel, or even someone on the technology side? What does that look like?
It takes a village. We're working across function. So, a lot of business units can be assets just in terms of helping you navigate bad vendor data, right? If you bring in procurement, you can at least know, who your current vendors are, right? They can assist you in, we've issued purchase orders for these vendors. Here are the ones we've got in the last 18 months. Let's go after these vendors. We know they're active versus, vendors who haven't had a purchase order and invoice in 24 months, right? Chances are they're probably not an active vendor. So you can leverage and utilize internal resources to benefit you. And then in terms of decision making and getting the organization on board for the process, you get legal compliance, privacy, obviously, infosec, and getting them all around the table so you're all on the same page.
Yeah, I mean, and you mentioned that earlier. This is sometimes companies don't know to do that, so you might have one person reaching out, and then presumably then you're facilitating getting all of the right people to the table to move forward in a way that the company needs to, right?
Yeah, absolutely.
I was laughing because I think we have some clients where I think there are people, there's no one we haven't spoken to, because yeah, it's not even so much a village. It's pretty much that you go so broad into the organization because it could be vendors could be doing anything with personal data.
Yeah, and you mentioned earlier also that this process and dealing with compliant data transfers is affecting, you know, small to medium-sized companies differently than larger companies. Just to, you know, I wanted to sort of close the loop on a lot of what we discussed today. How does anything that we discuss in terms of processes or who's at the table or what needs to be documented or, you know, the types of business decisions that are being made, does that differ, or even the challenges, does that differ from a big company versus a small to mid-sized company?
I mean, we're seeing smaller companies as being obviously less, well, they have less money to spend, but also in a lot of cases are less willing to spend it. And I think that's part of the, you know, if you're being chased by the bear, are these small companies really the ones that are going to be caught or have regulatory action taken against them? So it comes back to what we were saying earlier about kind of that risk decision. And what we're hearing from many smaller companies is we shouldn't really be, we can clean up the procurement process. We can do some things to make some of this stuff easier, but unless somebody comes knocking, we don't really need to go and worry about this too much. But then you look at the, I mean, 5,000 small companies across the US, well, 5,000, what was it, 75% of them were small and medium businesses had signed up for Privacy Shield. But you compare that 5,000 against how many companies there are in the US, there's still a lot that haven't done that and probably aren't doing much with the transfers at all. They're waiting to be caught rather than being proactive. But a lot of that comes down to, I think, the tone from the top. And if the board members have been at larger companies before, there's more likelihood that at least something will be done to understand that risk and then to work out what the right course of action is.
Great. And then, you know, we keep coming back to this, but Privacy Shield 2.0, let's look into our crystal ball maybe. And, you know, we keep talking about how some companies are taking that wait and see approach to all of this, and maybe they're holding their breaths for Privacy Shield 2.0, or like the survey suggests, they're thinking, why bother? It's a no-win situation. But with respect to Privacy Shield 2.0, what are your predictions? Aaron, maybe you could start with this. I know you have some thoughts on this. How likely is it? What issues are we seeing there?
Sure, I would say a couple of predictions. One is that I 100% anticipate there will be an agreement. But I also 95% anticipate that it will have a half-life about the same as Safe Harbor and Privacy Shield. There are a couple of fundamental issues that where there are differences between the US and the EU side, where I think they can get to an agreement. But I do think that without some changes to US law, even the concept of the ombudsman, that's one of the two major issues on the table. So one of them is having European residents the opportunity to complain directly to somebody in the US if they feel that their data is being handled inappropriately. And the other issue is around the perception of the over collection of personal data and the lack of equivalency of US versus non-US citizen in terms of kind of the rules around what data can be collected and how is it used. Not been helpful in the last couple of weeks, where there were some declassified documents that brought back up the bulk collection practices of the CIA back to the forefront. So I think there are some fundamental issues, but I had an interesting perspective from a European client this week, who said it's possible that in light of all of the Ukraine mess and everything that's going on right now, we'll realize that Europe and the US are closer together than maybe differences. And this is just a distraction from some of the real issues that we should be focused on. So they felt that that was actually something that made it more likely that we'll get to a deal quickly, which was an interesting perspective. So I do think that there will be an agreement that'll give us at least a couple of years to work through what that looks like. Maybe gives us a chance to go back and do some of the cleanup we talked about. But I think that the long-term agreement is probably going to require, if not a federal US privacy law, then something that really does go and address the root cause issues that are on the table there.
Jim, anything to add to that? Any
No,
more
just
activity?
what I had mentioned earlier, that you read an article as early as today saying that there may be an agreement in the May US EU tech meeting in France. So it could be shortly on the horizon.
Yeah, I guess we'll see how long before we see it, and then how long it sticks. Right, so I didn't see any. I think we said we were going to save questions until the end, and if anybody has any further questions, now would be the time to post them if you haven't already. I know we got to a few of them as we were moving along through our discussion, but you know, in the meantime, I just want to thank Aaron and Jim for helping us think through the practicalities of these challenges. Did you guys want to leave our listeners or viewers with any last, like you could tell them, leave them with, you know, putting you on the spot here, but leave them with, you know, 2 or 3 tips in terms of how they should be approaching, you know, this landscape right now?
Sure. There was one question in the Q&A that Jim kind of touched on around how far into the supply chain do you need to go? Can you, if you've got an organization you're working with, can you rely on their reps and warranties about the sub-processes that they are using? And while we're not providing legal advice on this call, Jim, do you want to maybe kind of reiterate the point that you made on your perspective on that?
Sure. So it's not so much of a perspective, but just a question that, you know, other companies are struggling with in terms of, you know, how far down the supply chain do you go? You know, do you start looking at your sub-processors and subcontractors, and are they in scope? Do you have to start pulling, you know, requiring your vendors, your primary vendors, to show you their TIAs on those vendors, so you know that, you know, if they're processing your customer data, that, you know, they have adequacy controls in place. And as far as I can tell, we, you know, technically do not, or we have not seen legal rely on existing reps and warranties from primary suppliers. I think they still want to have those SECs in place. So I think we've seen, you know, a push for those, just to probably err on the side of caution.
Yeah. Good. That was helpful. Thank you. And then, yeah, I mean, my takeaways from all this are that, you know, most companies are somewhere in the process, which was actually great to see. And that in essence, I think I'm hearing from you guys, is what I continue to hear is that companies continue to rely on their SCCs. And it might not be perfect, but it's all they've got, and they're not going to stop transferring data, because that's going to require them to shut down their business, and companies aren't ready to do that yet. Some are taking a deeper dive into areas we didn't exactly cover today, but they are in some of the articles on cybersecurity.lawreport.com in terms of looking at localization, Article 49 derogations, and then other measures or supplementary measures that can be put in place around these transfers, whether they're organizational or technical or contractual. So yeah, so in a sense, it's business as usual with a few more protections around it. So thank you both so much for all the helpful practical advice you've shared with viewers on this. Thank you to everyone for listening today and joining us. A recording and the slides, which I don't think you saw, but they will be made available. And there was a slide there where I just mentioned this, but there will be a list of further reading, which takes a deeper dive into some of the issues we discussed today, with a little more color around the laws as well. But feel free to, and our contact information is also on the slides, so feel free to contact any of us with any questions or even ideas you have for future webinars. Maybe we'll follow up on this one. I think we're all always happy to talk privacy and security. So thank you so much for tuning in.
I think one final thought, Jill, is that the companies we're seeing do best with this are not treating it as a compliance pain. They're really looking at it, and I think Jim touched on this several times, as an opportunity to really understand where the data is going and to get their arms around, because this will not be the last time we have to go back and look at transfers for one reason or another. So the companies that I've seen be most successful is looking at this as a business opportunity to do a better job of understanding. Maybe we can get rid of duplicate vendors. There's a whole bunch of other things if you're really digging into this beyond just getting those new SEC signed. And that's generally a better message for executives than we've got to go and do this compliance thing and it's going to cost us $1 million. So.
Right, we could do a whole other webinar on how companies can obtain those resources by making that business case that you so eloquently discussed just now, Aaron. That's a very good point.
Well, thank you all for attending today, and thank you, Jill, Jim, Aaron, so much for your expertise. There will be a recording that will be available, and the slides will be available, as well as a downloadable checklist to see how you're doing or progressing with your Schrems 2 projects. Thank you and good evening.
Thank you.